Hello, everyone, and welcome to Uncivil Law. And for today's story, we turn our attention to a popular streamer named Destiny, who has gotten into trouble for potential revenge photographs and videos. So this is a story we've sadly heard before, of course, from other people, and now it has come Destiny's way. So we're going to get right into this. We turn our attention to this civil complaint in the United States District Court for the Southern District of Florida in the case of Jane Doe versus Stephen Bonelli, otherwise known as Destiny, and she is suing for violations of her privacy. We're going to read this complaint and analyze it. This action seeks to hold defendant accountable for his unauthorized, intentional, and unlawful disclosure and dissemination of intimate images and sexually explicit videos of the plaintiff, thereby causing plaintiff extreme emotional and physical distress, depression, anxiety, and harm to her personal and professional reputation. Plaintiff seeks injunctive relief, compensatory and punitive damages, attorney's fees, and any other relief this honorable court deems just and proper as a result of defendant's unlawful, extreme, and outrageous conduct towards the plaintiff. The plaintiff brings this complaint pursuant to federal law, which allows us to go in federal court. We are on a federal case, so we are literally making a federal case out of it. And we have a federal cause of action, so no problem. The Intimate Image Protection Act, 15 U.S.C. 6851, and also the Sexual Cyber Harassment Statute, Florida statute, supplemental jurisdiction. So since the federal court can hear the federal claim on the basis of original jurisdiction because it's a federal claim, you can also bring along any associated claims for the ride, so bring in the federal statute as well. And other Florida law pertain to the right of privacy, public disclosure of private facts, and intentional infliction of emotional distress. The court has subject matter pursuant to law because this case arises under the laws of the United States. Easy enough. We're suing under a federal statute that gives us a federal cause of action. So that makes it easy enough. The court has supplemental jurisdiction because they arise out of the same nucleus of facts. Exactly so. Venue is proper in this jurisdiction pursuant to law because a substantial part of the events occurred within this district, and defendant is subject to personal jurisdiction in this district because he lives there. So we're suing him in the place where he lives. So that makes jurisdiction easy, and venue is proper because it also happened there. So no problem. That takes care of all those things. Plaintiff Jane Doe is a citizen of the United States and resident of Miami-Dade County, Florida. Plaintiff brings his complaint anonymously due to the intimate and sensitive nature of materials, which forms the subject matter of the complaint. Now, being able to proceed anonymously can be somewhat tricky under law, but under these circumstances with revenge photographs and revenge videos, you would imagine it will be granted. So shouldn't be a problem to remain anonymous there. Defendant Stephen Bonelli is a citizen of the United States and a resident of Miami Beach, Florida. Fine. Bonelli, otherwise known as Destiny, is a live streamer and political commentator. He has over 840,000 subscribers on YouTube. He has a huge following on X, Kick, Reddit, and Discord. And Bonelli had over 700,000 hours on his Twitch channel before he was banned due to conduct, although she describes it as hateful. I won't take a position on that issue because Twitch's going to do what Twitch's going to do, right? But yeah, he's been a controversial streamer from time to time. He's been banned from Twitch and I think unbanned from Twitch and maybe rebanned from Twitch. I can't even honestly keep track anymore with some of these things, you know, with these social networks. But he's been a controversial streamer, gamer, political commentator, left-leaning guy. He's been on other major podcasts. He's been on other major debates, notable commentator on the left. So, I mean, he's been very notable. I've talked to him 2 or 3 times on his channel. He was cordial to me. He was, you know, it was fine. And he's a controversial guy and, you know, he's popular with a lot of people. So, you know, fair enough. The plaintiff, also known online as Pixie, is also a live streamer as well as an influencer. Now, I don't really know why you would say your handle here as the plaintiff if you want to remain anonymous. That seems like a really bad plan, right? Like, I want to remain anonymous, but I also want to tell you my social media handles, like in the complaint. It's like I can probably figure out who you are. So, like, what's the purpose of bringing it anonymously? I don't quite understand that one. That's odd to me, but okay. The plaintiff, also known online as Pixie, is also a live streamer as well as an influencer. Pixie has 15,000 subscribers on X, and on Twitch, she has 10,000 followers. Okay. Plaintiff began conversing with Bonelli on Discord when she was approximately 19. Benelli was approximately 33. At the time, plaintiff was a new streamer in the same niche as Benelli, politics. Approximately 2 years later, on or about September the 12th of 2020, after multiple conversations about consent and boundaries, plaintiff engaged in sexual relations with Benelli. Plaintiff was inexperienced and only had physical relations with another person prior to Benelli. This was the only time plaintiff and Benelli had sexual relations. During this one occasion, Benelli recorded videos of plaintiff and himself engaging in sexual conduct. That's okay. It's a little weird, I think, for a first time to be videoing. That seems like a bit more of an intimate act for more long-term partners, I would think. But, that's the way they want to roll, I guess. So he took video of their experience together. Okay. I mean, if it's with consent, it's with consent. Go with God, I guess. So that's fine. Unbeknownst to plaintiff at the time, on or about October the 4th of 2022, Benelli disseminated through electronic means one of the videos to a 19-year-old woman using the screen name Rose. And now we run into problems. Yeah, you can't do that, right? You can't send the intimate images under the operative law of many states. I think 49 states. I'm not sure South Carolina has a revenge porn law. I think they might be the last holdout on this issue. And also, of course, federal law, although that's a more recent development as well on this issue. So basically every single state prevents you from sending these images. Of course, it is worth noting that the laws of the various states, of course, differ as to their specificity about exactly what you can do and can't do. So trying to give advice is problematic for that reason. But if you're sending images of an intimate nature to someone other than your partner, you might want to check with your operative law before you do that. Or, get their consent would also be not the worst idea ever. But, just FYI, it can be a little bit legally tricky. It's also worth noting, of course, that some version of these might be unconstitutional. Although which one is the question, right? So in their various manifestations, these states have tried to make something illegal, but they're making it illegal based specifically on the subject matter of the content, right? It's a content-based restriction, which means you're subject to strict scrutiny on the constitutional analysis. So some, but I don't necessarily think all of these revenge laws will withhold constitutional scrutiny, but that's another problem for another day. For the moment, we can presume the statute is valid as the court proceeds. And if we get into a constitutional fight, we'll get into it later down the road. On or about November the 29th of 2024, the sexual explicit images of video of plaintiff that Benelli had shared with Rose was uploaded to the website Kiwi Farms. Why does Kiwi Farms always seem to make an appearance in these things? The video was also shared on multiple other pornography websites, including notfans.com, ThoughtHub, PornBiz, ePog, and eRome.com. I've not heard of any of these websites. I'm running in the wrong circles, I guess. The caption on the video of the different platforms identifies both Destiny and Pixie. The plaintiff's face is visible and identifiable in the video. Shortly after the video is posted, various friends and random followers of plaintiff informed her about the dissemination of the video. Some of the messages are very accusatory. She is shocked, humiliated, and mortified by the dissemination of the video. As of the day's date, the video has been viewed on notfans.com over 10,000 times. It has been viewed on ThoughtHub 58,000 times. It has at least as many views on other websites, but has since been removed. It's still on Kiwi Farms, but the site does not have a number tracker, so the number of views is unknown, but estimated to be in the tens of thousands. On arome.com, there were 10,000 views, but has since been removed. On the evening of November the 29th of 2024, plaintiff sent a message to Benelli on Discord expressing her horror that he shared a video of her. She asked him if he sent any additional photographs and videos to anyone. He admitted his guilt by responding, "Ugh, there shouldn't be, no. I'm sorry, there's no literal excuse. I had phone convos and stuff with this person that were fairly close to me. It's worthless to say at this point, but I'm super sorry there's no excuse." Well, probably not, no. No, probably not. I mean, unless you have consent or you don't fall within the technical definition of the statute for some reason, or you're going to make a constitutional argument, I don't know exactly what you have left. So you're going to have a statute of limitations, but these are all last year. So not so much there. So I don't really know, other than I just didn't do it. But yeah, your defenses are running out rapidly here. The leak of the video goes viral and is being discussed by thousands of followers of Destiny and Pixie on various platforms, including YouTube, Discord, Reddit, Kiwi Farm, and Twitter X. Plaintiff began receiving hundreds of insulting and harassing messages. Many of the followers discussed the leaks on different accounts, falsely claiming that Plaintiff exchanged sex for professional growth and favors from Benelli. Yeah. Plaintiff feels increasingly humiliated, mortified, and depressed, and starts to feel self-harm. On or about December the 11th of 2024, she started writing notes of self-harm nature. Plaintiff messaged Benelli, and she tells him she's just tired of living anymore. It's a matter of time until my family discovers what happened. I feel like the best thing for me to do is kill myself and schedule a post just detailing my feelings on what happened to try to ensure a situation like this doesn't happen again. Plaintiff then unfriended Benelli on Discord so she cannot receive any messages from him. Fair. I mean, this is, it's intimate. And having your intimate stuff put out in the open is not really fun. So, I mean, her feelings are pretty understandable. Plus, also on a legal level, strictly speaking, on the underlying issue as to the revenge porn, they're irrelevant. As to the emotional distress, it's relevant, right? So as we're trying to parse that out legally, like the fact she feels in one way about it doesn't really matter as to the revenge porn, right? She doesn't have to feel a particular way about it. It just has to be without consent. So her feelings go more to the intentional infliction of emotional distress. Now, of course, as I point out before, IIED, intentional infliction of emotional distress, is a difficult claim legally. The number one thing is it has to be done intentionally and basically for the purpose of causing distress in the other, and it's conduct that is beyond the pale. So IIED is a disfavored claim. So, I mean, you can try to bring it and, she might have been wounded by it, but she has to prove basically that Destiny did this with cruelty in mind. And that's not necessarily readily apparent from this. So she might have problems proving that claim, but we'll deal with that as we go. On or about December the 13th of 2024, Plaintiff met with Benelli's close friend and business associate, Kyla Turner. Plaintiff tells her about the suicidal thoughts, that she cannot bear the humiliation and harassment she's enduring, and she wants to ensure Benelli does not do this to anyone else ever again. Sliding Edge gives $5 to say Destiny has demonstrated multiple times his shallowness of character, poor reasoning skills, and cognitive dissonance. He's quick to disregard people. Yeah, fair enough. Fair enough. I don't necessarily have enough information myself to make any global judge of his character. My interactions with him were very limited. I wasn't very happy when he said that he didn't really care about the fact that gentleman, the firefighter, was killed in Pennsylvania when they tried to shoot at the president. He's basically saying he had no sympathy for the person because he was a Trump supporter. I wasn't really happy with that statement. So, I mean, he has questionable views at sometimes. On or about December the 19th of 2024, Turner asked Plaintiff if Benelli had communicated with her or added her back as a friend. Plaintiff responded in negative. Plaintiff continues to feel depressed and suicidal. The leak of the video is still a viral topic of conversation around mobile platforms, with people making horrible accusations about Plaintiff. On the morning of January 20th, 2025, two videos on YouTube are posted by two different streamers discussing the Pixie leak. These videos include screenshots of private messages of the plaintiff discussing the situation with friends, and plaintiff took hush money, only cares about money, does not care about the victim's defendant. These videos have been viewed thousands of times, including one, which as today has been viewed 90,000 times. The majority of the people assume Benelli share the videos with Benelli's consent and knowledge, which, given the state of the law, is not necessarily a wholly unreasonable conclusion. But these statements are basically going to damages, right? It's like the idea that you did something to me that has caused me emotional harm, and these people are now commenting on it and causing me further emotional harm based on the thing that you did. So, you kind of eat it. That definitely can work as a legal theory if you get past the underlying issue. So if you get past the underlying issues relating to liability, but it can definitely work. As to the IIED claim. Yeah, Sliding Edge said he even doubled and redoubled down on his take on the Trump supporting firefighter. I'm well aware that he doubled down and redoubled down about that. I wasn't a happy camper. Yeah. So that sort of personally put me off from wanting to talk to him in the future. And, because I wasn't really happy with that statement. So I was like, I don't necessarily want to associate with you anymore. So, yeah. What are the states in question? Isn't it Florida? Yes, they're both in Florida, but this is not diversity jurisdiction. This is federal question jurisdiction. We're suing on the basis of a federal statute. So the fact that they both live in the same state is fine. So, yeah, but good question. Good observation. On or about January the 20th of 2025, in desperation, plaintiff Pixie goes online and announces that Destiny shared the videos without her consent or knowledge, and she'll be seeking legal recourse. The same day, Benelli Destiny responded on various platforms, including Reddit and Imgur, and falsely claimed that the video leaked happened without my knowledge, consent, or authorization, which, okay, if that's true, might relieve him from the statute. Because he, under the statutes, you have to make the decision to post it. So if the data was stolen off his hard drive, right, if a hacker got it and posted it, without his knowledge, then Destiny wouldn't necessarily be responsible for that because he wasn't the one that posted the images. So if it really was done without his consent, then, fine, but that doesn't seem to be true. But, if he wants to argue consent, if he wants to argue that he didn't post it, then, that would work. This claim directly contradicts his November 29, 2024 explicitly written admission that he knowingly and intentionally shared the video with Rose without consent. Well, I'm not sure it's that explicit. I as the lawyer in me would prefer something a bit more explicit, but sure, for the moment, why not? Billie Jean in chat says he's admitted he shared the video with 3 people. Well, when those 3 people provide an affidavit or otherwise provide that information to the court, we can rely on it as part of the court proceedings. But as I'll remind everyone, when we're in a court proceeding, nothing exists unless it's on the record. So for the moment, those 3 people don't exist because it's not on the record. So we'll deal with it when it comes into the record, because it's only fair. We can only adjudicate a case based on the information that's available in the case. So we'll proceed on based on what we know within the confines of the case. On January the 20th, right out after plaintiff announced publicly that she would sue Benelli, one of the followers reached out to plaintiff and told her Benelli had sent the video to her sister about 2 months earlier. The follower confirms that plaintiff, she believes Benelli is still sending the sister explicit videos of message without their consent. So we have someone who's reached out to plaintiff, who's relaying that this Benelli sent this to another person, apparently. Okay. On January 21st of 2025, aware of an impending lawsuit and potential criminal investigation, Benelli started destroying evidence, including deleting messages between him and plaintiff, which definitely could go to show consciousness of guilt. On January the 23rd, 2025, Benelli received a letter from plaintiff's counsel informing the desire of intent to sue and demanding he preserve all evidence. Now, it's interesting because in terms of preservation, you sort of have to preserve stuff once you're aware of the lawsuit, and you don't necessarily have to be served with it. So she might even be able to get to spoliation for the stuff he deleted if he was aware that a lawsuit was imminent. So, right, if you're aware a lawsuit is imminent and you start destroying files, then you can actually get an adverse instruction from a civil court. It's possible, right? It's like you destroyed it even with knowledge of this lawsuit. So that's a spoliation. And when you do that, you can get sanctions, including potentially the judge telling the jury that they're allowed to basically assume the worst, right? You get the adverse inference. You can get an adverse inference instruction. You can get the judge telling the jury, you can assume the messages were really, really bad. Let your imaginations guide you. So yeah, that's definitely a thing that could happen as a result of that. It's good times had by all. I mean, you destroyed the evidence, right? So it's your fault, right? Yeah. On or about January 23rd, 2025, Benelli began to publicly harass and defame plaintiff. He posts in his group cast called DGG with multiple people that Pixie is just after money. On or about January 23rd, 2025, Benelli also posted on his website, destiny.gg, and in his DGG chat that Pixie and the people behind her just want money. So there's no point in going after the hacker. He's probably just some broke loser anyway, so why aren't they even mentioning him? Again, if he was truly hacked and the information didn't come from Destiny, that would be a pretty solid defense. But it seems like that we have at least two people who seem like that's not what's going on. So, okay. And then the fact he's destroying messages isn't helping with the defense. Benelli attempted to divert blame from himself and cast blame on an alleged hacker is directly contradicted by his own prior explicit written admission to plaintiff he intentionally shared the videos and by his text message with Rose in which he tells her about the video with a young girl he'll send her. Well, that sort of doesn't suggest hacker. That sort of suggests I sent it. No, that's not great. Benelli continues defaming and harassing plaintiff on his website, destiny.gg, and in the DGG chat. He implies plaintiff is trying to milk him, and she's not going after anyone else that might have been allegedly involved in the leak of the videos because she can't milk as much money as the target. Well, she may not know who those people are, one. And also, everyone else is speeding, therefore you can't pull me over for speeding is a shit defense. That doesn't work. Okay? She may have causes of action against other people. She can choose to sue those people or not. She's chosen to sue you. The operative question isn't whether or not other people have liability. The question is whether you have liability. I'm sorry the cop decided to pull you over for speeding. I know everyone else was speeding. I know the cop could have pulled over anyone else. They picked you. Sucks to be you. Sucks to be you. This is the everyone else was speeding, so you can't pull me over defense. Lol, no. So first of all, she may not know who they are. Second of all, even if she does, she can sue you. Third of all, if the images originally came from you, if you are the source of this thing, then you're arguably the most responsible because you're the origin of this thing. So you seem like a pretty reasonable target to me as a person. So, maybe we'll sue those other people later. Who can say? Potentially over 1,000 people have seen this post. In or around the end of January 2025, approximately 15 people reached out to plaintiff to tell her they had received sexually explicit images from Benelli of other women without those women's consent. These 3 women also tell plaintiff that Benelli deleted these chat threads. Neat. Other women may appear in this case. Other women may file their own lawsuits, being encouraged by this. So yeah, this is not good. Upon information and belief, mobile women, including, and she says their name, which I don't. Okay. Upon information and belief, mobile women, including Melania Gorson and Stacia, have recently come forward and publicly alleged that Benelli has released sexually explicit videos of them without their consent. Upon information and belief, these images were then posted on different pornographic websites without their consent. Is it not Benelli? How do you pronounce his name? Bonnell? It's Bonnell? Oh, it's Bonnell. There's no I. It's Bonnell. Okay. Sorry. Bonnell. I apologize. My mistake. My bad. Upon information and belief, mobile women alleged that Bonnell have released sexually explicit videos of them without consent. Upon information and belief, these images were posted on different pornographic websites without their consent. A woman with the screen name Cherry. I'm going to go with Cherry. A woman with the screen name Cherry recently found out that Bunnell had secretly made unauthorized audio recordings of their interaction and distributed to multiple people without knowledge or consent. As to audio recordings, I don't know whether or not that's illegal off the top of my head, to be quite honest. Most revenge porn laws I've seen refer to videos and images. I don't know whether it's illegal to distribute sexual audio. I'd have to check the relevant statutes. Fun. Yeah. Bunnell had retaliated against Cherry by publicly posting private messages during a time when she was suffering a mental health crisis, which isn't exactly a strong move. On or about January 23rd, 2025, Bunnell began a smear campaign against Plaintiff and tells his follower that Plaintiff is only interested in getting money from him. Over 1,000 of his followers could have seen this post. He also tells his followers that his only crime was being too much of a gooner. The word gooner is slang for someone who's deeply engaged in excessive adult X-rated consumption, sometimes in a compulsive or obsessive manner. Well, you can goon as much as you like. You just can't share the images of other people without their consent. There's so much images out there. There's a lot of it, man. There's a lot of it. I'm sure you can find something that you like somewhere, man. Wouldn't the audio fall under two-party or one-party consent as to the recording itself under wiretapping law? Sure. But that's not the issue necessarily, right? We're not necessarily talking about wiretapping law. So as to whether he can record the audio without her knowledge, sure, that would be a one-party or two-party consent state issue. Florida, as best as I remember, is a one-party consent state. So he can record it without her knowledge. That's fine. We're not talking about recording it, though. We're talking about distributing it. And that's a whole nother set of problems because of the revenge porn laws we've been talking about. Yeah, but good question. Good question. I like your questions. These are good questions. 2 good questions so far in chat. I like good questions. Keep them coming. On or about January, and you can correct me on pronunciation. Pronunciation sometimes and I don't get along well. On or about January 24th, 2025, another female political streamer talks about Bunnell sharing of videos. She informs her followers that Destiny Bunnell had recorded a conversation without her knowledge or consent. She alleges that after their personal relationship deteriorated, he became publicly hostile towards her. And then later he posted his followers that he had a recording and he could publish it. Then on February 9th, 2025, after posting a link to a clip of her talking about sharing the video, Bunnell retaliated against her by posting private sexual text messages between them to his community chat group. That's not a good look. Yeah, that's not a good look. Discovery on this is going to get interesting, I imagine. On or about January 26, 2025, Hannah Brooke, a follower of Bunnell, contacted plaintiff and informs her that even after the video was publicized on November 29, 2024, Destiny Bunnell offered to send the video to her. A few days later, another follower posted Brooks' direct message with Bunnell. After the messages go public, Bunnell deletes his message with Brooks in an attempt to cover it up. It sounds like it's revenge at this point, right? It sounds like he's doing it for the purpose of revenge. He's willing to share these things to get back at her, which isn't necessarily incidentally within the scope of the statute in terms of motivation. You know, the motivation is not usually motive is not an element here. So why he's doing it is not an element of the tort, but it's notable that he's doing it because he wants revenge. That's not good. On January 30th, 2025, Destiny Bunnell admits he's been actively deleting evidence of wrongdoing, specifically his messages with multiple women who have claimed that he shared sex videos with them without consent. On or about February 8th, 2025, Bunnell posts to X. He agrees with another post that claims that plaintiff is trying to extort him. On or about February 9th, 2025, Bunnell makes another defamatory post on X, telling his followers that plaintiff only cares about getting money from him. He also informs all of his followers that the video can still be seen in Kiwi farms. He on X told people where to go look for the video. Holy shit, dude. Like, this was totes stolen by a hacker. But here's the URL to go view me having sex with my ex. But it was totes stolen by a hacker, though. I'm having a hard time believing that, man. Yeah, I'm having a tough time with it was really a hacker, though. With that fact pattern, that doesn't sound good. The video disclosed by Bunnell were of a private nature and never intended for public dissemination. Defendant's actions have caused plaintiff severe emotional distress, humiliation, and reputational harm. Plaintiff's career as a political streamer has been adversely affected, and her aspirations of being elected for office have been greatly diminished. I don't know. It's the story. The story can definitely be part of a positive campaign someday. Can merely posting non-consensual content to personal online storage technically violate revenge law? To the best of my knowledge, no. It has to be shared with another person. And so, no, merely putting it in cloud storage, I do not believe would violate the statute, no. But again, you'd have to read it carefully, but almost certainly not. Because if at that point, it's just your own personal storage. You're not sharing it with anybody else. So, no, but good question. All right, count one, violation of 15 U.S.C. 6851. All right, so what we're going to do real fast is we're going to pull up the statute. So just give me a second to do that, because I think it would be nice to actually look at the elements of the thing so we can see what exactly is being criminalized, because that sounds like a reasonable thing to do. Or in this case, civilized instead of criminalized. It's criminal too, but this is the civil version of it, right? All right, so let's look at this statute. Okay, I have to redo my margins because... I try to make things look pretty, and then different pages use different layouts, and it makes my life complicated. It's a very sad life for me. All right. So here's the federal statute, 15 U.S.C. 6851. Civil action relating to disclosure of intimate images. Okay, in this section, commercial pornographic content. The term commercial pornographic content means any material that's subject to record-keeping requirements. The term consent means affirmative, conscious, and voluntary authorization made by an individual free from force, fraud, misrepresentation, or coercion. I'm not exactly sure why we need to define consent. That sounds like the definition of consent, but fine. The term depicted individual means an individual whose body appears in whole or in part in an intimate visual depiction and who is identifiable by virtue of the person's face, likeness, or other distinguishing characteristic, such as unique birthmark or other recognizable feature, or from information displayed in connection with the visual depiction. So if we can tell who you are from the imagery by face or some other aspect, you telling us metadata, whatever. The term disclose means to transfer, publish, distribute, or make accessible. The term intimate visual depiction means a visual depiction, as that term is used in law, that depicts uncovered genitals, public anus, area, anus, or other post-pubescent female nipple of an identifiable individual. The display or transfer of bodily sexually fluids onto any part of the body of identifiable individual from the body of an identifiable individual or an identifiable individual engaging in sexually explicit conduct. Includes any visual depictions described in subparagraph A produced while the unidentified individual was in a public place only if they did not voluntarily display the content depicted and or consent to the sexual conduct depicted. So if you're taking photographs of someone flashing themselves, the statute doesn't apply. If they chose to flash themselves in public, right? So that's what that's contemplating, right? So if it's done in a public place, if you flash them and we can see your nipple, then, sucks to be you. It's too bad, so sad. So maybe don't flash yourself, I guess. The term sexually explicit conduct has them, or if you walk around naked in public, because some jurisdictions allow nudity in some places. So if you're in a place that allows nudity and there's nipples to be seen, then, it doesn't violate the statute because they chose to expose that. So, it's fine. No expectation of privacy, basically, right? You didn't have an expectation of privacy in public. So, and you chose to expose it. So that's how that goes. The term sexually explicit conduct has the meaning given in some paragraph A and B. All right. Except as provided in paragraph 4, an individual whose intimate visual depiction is disclosed in or affecting interstate commerce, which of course, we know what that means. It means anything you want to mean. In this case, no problem though. We're using like cell phones, we're using computers, we're using wires. So like we don't really have to fight very hard about whether it's interstate commerce. That's no problem here. Without consent of the individual, where disclosure was made by a person who knows that or recklessly disregards the individual is not consented, may bring appropriate civil action. So, fair enough. And then we define consent a little bit further, and there's relief. An individual may recover actual damages or liquidated damages in the amount of $150,000 and the cost of this action, including reasonable attorney's fees and other litigation costs. So, okay, you can get your attorney's fees. The court may, in addition to any other relief at law, order equitable relief, including temporary restraining order, preliminary injunction, or permanent injunction, ordering the defendant to cease display of the images. And then the preservation of anonymity. In ordering relief, the court may grant injunctive relief maintaining anonymity. So the statute contemplates proceeding anonymously, which continues to confuse me why she referred to her screen name in the complaint. But I mean, you do you. Exceptions. An individual may not bring an action for relief in the section relating to an intimate image that is commercial, and that's where the record-keeping requirement was maintained, we talked about earlier, so if it's professional, unless that content was produced by force, fraud, misrepresentation, or coercion. So if you choose to, do the sexual content for like the monies and do a little pornography, the statute does not apply to you. So, sorry, you don't get to revenge porn your voluntary professional engagements. So no. A disclosure made in good faith to a law enforcement agency as part of a legal proceeding, as part of a medical diagnosis, or reporting the conduct. So if someone is doing it for these reasons, then no, because these are good faith reasons, right? So that's fine. As a matter of public concern or public interest, I'd love to see him try to squeeze himself into that statute. That'd be good. That'd be really great. That'd be a one hell of a defense. Let me try to squeeze myself into this. That'd be good. I did it because it's a matter of public concern or public interest. Destiny is a public figure. He's a very popular public figure. So watch him try to squeeze himself into this exception. That might be mildly hilarious if he goes that way. That'd be fun. That'd be fun if he wants to try that. I did it because the public needs to know. A disclosure reasonably intended to assist in identifying an individual. Okay, well, fair enough. That is what the statute has to say on that issue. Cool. How is public humiliation handled civilly? Well, it's going to be in a different claim. It's going to be in an IIED claim or something else like that. So how is the humiliation covered? It's not going to be covered here. It's going to be covered by a different cause of action. And we'll get to it as needed. Defendant knowingly and intentionally disclosed the explicit videos without knowledge or consent. Identifiable in the video. The video has been viewed thousands of times and continue to be viewed. The leak of the videos by defendant and plaintiff's role in the videos has been disclosed online by thousands of people. Okay, you know what? I actually just had a thought, and it's actually, I don't even know if I should say it out loud. Yeah, I'm gonna not say that out loud because that sounds like a bad thing to say. I'm gonna maintain my. I just had a legal thought, and I don't want to say it out loud. Isn't transferring to the online storage within the definition disclosed? Isn't storage provider a third party? No, I wouldn't say so. Not in my view. I don't think it falls within disclosure. Yeah, is the term disclose defined? Yeah. So the term disclose means to transfer, publish, distribute, or make accessible. I mean, I see what you're saying, that technically you could view that as a transfer, but I don't think so, because I still think it needs to be to somebody else. I don't think the statute contemplates transferring to a cloud storage server. It's not publishing, it's not distributing, because you're not, I appreciate it. I appreciate your reading, but I'm going to say no. I wouldn't read it that way, but I appreciate the thought. Yeah, sounds like a members only legal thought. Yeah. As a direct result of the defendant's conduct, plaintiff has suffered extreme emotional distress and harmed her reputation. All the above actions of the defendant violate 15 U.S.C. 6851, and accordingly, plaintiff is entitled to preventative and injunctive relief requiring defendant to delete the videos and barring him from further disclosure, actual damages in the amount to be proven, or alternatively, liquidated damages of $150,000, whichever is greater, punitive damages and reasonable attorney's fees and costs. Okay, fair enough. Count 2, violation of Florida's law. All right, and we can go look that up too, so we can see what the elements of that statute are, because it's always fun to learn. Let's look up Florida's law and see what it has to say about this issue. Okay. All right. And again, the margins. Always a problem with the margins. All right. This is Florida statute 784.049, sexual cyber harassment. The legislature finds that a person depicted in sexually explicit images with that person's consent may retain a reasonable expectation the image will remain private. It's becoming increasingly common for people to publish these. When they're published, that's bad. The dissemination is bad, blah, blah, blah. Okay. Image includes, but is not limited to, any photograph, picture, motion picture, film, video, or representation. Personal identifying information includes any information that identifies an individual and includes, but is not limited to, name, postal or electronic mail address, telephone number, social security number, date of birth, or any unique physical representation. Sexual cyber harass means to publish to an internet website or disseminate through electronic means to another person, and this statute actually explicitly says another person, which is nice, a sexually explicit images of that person that conveys the personally identifiable information of the depicted person without the depicted person's consent, contrary to the depicted person's reasonable expectation the image would remain private for no legitimate purpose, with the intent of causing substantial emotional distress to the depicted person. Evidence the depicted person sent a sexually explicit image to another person does not remove his or her reasonable expectation for that image. So even if I sent you the nude, that doesn't mean that I'm consenting to you further distributing it. That's what that's saying. So uncivil, salacious pics sent to you by Uncivil law remain for your eyes only. No sharing. Sexually explicit means any image depicting nudity as defined by law, or as depicting a person engaged in sexual conduct as defined by law. Except as provided in paragraph B, a person who willfully and maliciously sexually cyber harasses another person commits a misdemeanor in the first degree, punishable as provided by law. And then, so that's the criminal statute. And then there's a element here, section 5. An aggrieved person may initiate a civil action against a person who violates this section to obtain appropriate relief, including injunctive relief, monetary damages to include $10,000 or actual damages as a result of the violation, reasonable attorney's fees and costs. So just another way to get you there. Yeah, just another way to get you there. So that seems reasonable. Also, I don't think, because the code, the 15, I don't think either statute contemplates audio. Because, the federal statute talks explicitly about visual representations, and the examples in the Florida statute talk about visual representations. So I don't think either the Florida statute or the federal statute contemplate sharing audio only of your sexual encounters. I don't think either statute contemplates that. as best as based on my initial read. Is the civil complaint likely to go to discovery? What are the next steps? Next step is a motion to dismiss for failure to state a claim and or an answer is the next steps. And that can take a while depending on what the nature of the motion to dismiss is. So let me think. No motion to dismiss comes immediately to mind. Nothing is popping into my mind immediately. There's a prima facie case here. There's a prima facie case. It's a federal statute. Yeah, I'm struggling to think of a motion to dismiss off the top of my head. I mean, you could make a 12B6, but it's a loser for failure to state a claim, but it's a loser if you want to waste some time and give you some more time. So probably the next thing is probably a 12B6 motion to dismiss for failure to state a claim. It's a loser. The claim is valid on its face. It's prima facie valid on its face. So yeah, that's kind of the end of that discussion. Jurisdiction isn't a problem because we're where you live. Venue isn't a problem because we're where you live. The federal court has jurisdiction because of the federal statute that explicitly gives them jurisdiction for this. So it's a federal question. So no defenses immediately come to mind. So then so you can do the 12B6, but it's a loser. Then your next step is an answer after that's denied, in which you're going to deny every single claim because of course you are. And then you might make some affirmative defenses on top, like consent, and you might make some other affirmative defenses like I was hacked and other things. And then, there's a motion to then there will be probably a motion for dismissal and a motion for summary judgment, which almost certainly won't be granted because there will not be sufficient facts to make either of those decisions. And then we're off to discovery. That's probably the next steps in this thing, if it follows the typical path. So we'll see. Does the law not going into effect after the video is being sent not apply? I'm confused by your question. If the law was not in effect, it can't have criminal impact. It could potentially have retroactive civil impact. That's technically possible. But if the statute didn't exist at the time the images were sent, then there would be no liability, but I'm confused. We just read the statutes. There's no issue here relating to the statute's date of applicability. Can you do an insanity defense? I suppose, but Destiny's not insane. I mean, insanity would defeat the mens rea of the intentionality, but he's not insane. He's not even close to insane. He's lucid. Will this settle? Quite possibly. What percentage of suits go to verdict? Very few. Very few. Very few cases go the distance. Because most people settle for a variety of pragmatic reasons. So the probability of the settling extremely high. Is mens rea required in a civil suit? Sure, at least negligence, typically. Yeah, at least negligence is typically required. Yeah. And here the law talks explicitly about intentionally. I mean, we read the mens rea in the statute. It talked explicitly about intentionally and knowingly and recklessly and all the rest of it. Those are mens rea words. So sure. All right. Florida sets out a statutory cause of action, which certainly does. Defendants knowing and willful dissemination. See, knowing and willful. That's intention. That's mens rea language. Of sexually explicit videos of plaintiff to other people through electronic means without plaintiff's consent and in violation of her expectation they remain private constitutes cyber harassment. Defendant acted intentionally or reckless disregard. More mens rea words. From plaintiff's rights, causing plaintiff to suffer damage. Defendant shared the videos for no legitimate purpose. Does the court have to give permission to file a lawsuit as Jane Doe? The way I read the federal statute, no, I don't think so. It seems to contemplate privacy. Yeah. So, I mean, I don't know whether or not she has to ask for permission or not, but it'll be granted almost certainly. And the federal statute seems to contemplate it. So I don't think privacy is going to be a problem. Is there a possibility of a criminal trial or Destiny getting registered from this? From this? No. But from a criminal complaint brought by the government? Sure. But, you know, that's up to the government whether or not they believe they can prove a criminal charge beyond a reasonable doubt and whether or not they want to choose to prosecute this in their discretion. So whether or not criminal complaints are coming is an issue for the government. Tens of thousands of people have viewed the video on different platforms. They're aware of the release of videos and have engaged in online discussions. As a direct, natural, approximate, and foreseeable result, plaintiff has suffered damage to reputation, emotional pain, and suffering. Seek injunctive relief to destroy the video, stop disclosing, and cease harassing. Seek statutory damages or alternatively actual damages for medical expenses and punitive damages no less than $1 million. Okay. Can I speak to the fact she tried to get money from him before bringing the lawsuit? Is that extortion? Depends on the nature of the issue. It can get very technical very fast, but not necessarily extortion. No. Whether or not it's an attempt to settle a claim is not extortion. So it depends a lot, like exactly what's being said, right? So if I come to you and I say, like, you hit my car, right? You hit my car and I say, I want $10,000, and if you don't, I'm going to sue you. That's not extortion because I'm trying to settle a claim. It's a valid claim. So, you know, I can sue you or you can give me $10,000, right? But if I'm like, give me $10,000 and I'll tell people about how you cheated on your wife, that's extortion, right? So it depends a lot exactly what's being said. Could the results of the civil suit be used in a criminal trial? Possibly, insofar as the civil suit exposes evidence that the government might want to be used. The government might be able to reuse evidence the civil suit exposes. That's possible. The results themselves won't be used in a criminal court. A jury in a criminal case will never hear about this lawsuit, but they might. The evidence might translate. That's possible. Defendant conduct of disclosing videos without plaintiff's consent was either done intentionally or with reckless disregard of the probability of causing plaintiff emotional distress. Defendant acted in a way that it should have known caused severe emotional distress. But the problem here is the intentionality, right? That's the intentional infliction of emotional distress. That's a challenging cause of action. Yeah, that's a challenging cause of action. He did it with intentionality or reckless disregard at the time of disclosing the videos to the probability of causing emotional distress. That's a tough cause of action. That's a tough cause of action. IIAD is a disfavored claim. Defendant acted in a way that he knew or should have known that caused severe emotional damage. The defendant's actions were so extreme and outrageous, they go beyond all possible bounds of decency. Even after defendant became aware plaintiff was expressing suicidal intentionality to do the videos, he continued to disclose the videos to other people without consent. Maybe there with the stuff after the awareness of it, maybe. Because then he had actual knowledge of her emotional state and he continued doing it anyway. Maybe for that stuff. So maybe not for the initial distribution, but maybe for the later distribution and later referring. Maybe there's something there. As a direct, natural, proximate, foreseeable result of the intentional harassment, they suffer damage to reputation, extreme emotional pain and suffering, severe mental anguish, anxiety, and loss of dignity, and entitled to compensation in the amount of not less than $1 million. Because defendant's conduct was intentionally and recklessly indifferent, he's liable for punitive damages not less than $1 million. Count 4, invasion of privacy. Plaintiff adopts for the facts. Defendant publicly disclosed private facts concerning plaintiff that were not legitimate, including sexually explicit videos without consent, and continued to do so. There's no public concern that justifies disclosing the images. At all times, they acted intentionally and with reckless disregard for plaintiff's well-being. Defendant should have expected public disclosure to arise from its dissemination. Public disclosure would be highly offensive. Disclosure took place such that tens of thousands of people have viewed the video. They have a reasonable expectation of privacy, and disclosure costs extreme humiliation. This is a backup claim. This claim folds into basically the distribution claim. So claim 3 is iffy, claim 4 is repetitive, claims 1 and 2, maybe. Yeah, claims 1 and 2 look more promising. Claims 1 and 2 are going to drive this thing. Wherefore, plaintiff requests judgment as follows: for appropriate compensatory and statutory damages, for appropriate equitable injunctive relief, for an award of punitive damages, for award of fees, and for such other relief as provided. And they want a trial by jury, which you always ask for, because you have to in the federal system. You always ask for it. You can always waive it later. So, they always ask for a jury trial every single time because they want to preserve the option. Signed by Carlos Garcia. Well, Carlos, I think that this is a reasonable complaint. It looks valid on its face. It's prima facie valid, is what you can say. It's valid on its face. It provides enough information to make out the elements of the tort. It provides enough information. It's notice pleading, of course, in the federal system and most states for that matter. It's notice pleading, so you just have to put them on notice. You just have to provide enough information to make it clear what you're being sued for. What did I do? Right? What did I do? And this provides enough information. And it provides even some evidence to support it. It's prima facie notice pleading. Looks valid on its face. So in terms of response, I don't really see what's going to work here. The motion to dismiss, I don't know what you do. I don't even know what you write up in 12b-6. I don't know. I'd try to cobble something together as a lawyer, I think. I try to cobble something together probably. But, if not the motion to dismiss, then the answer and any counterclaims that he might have. So if he feels like he's been extorted or he feels like he's somehow been mistreated, maybe some counterclaims that he files. I'm not sure what those would be. Obviously, I don't know what's in his head, but maybe he thinks of a counterclaim and wants to bring that. I don't know. And then there's going to be so after the answer, there's going to be a motion to dismiss and a motion for summary judgment, which will be denied both ways. And then we're almost certainly off to discovery, which includes depositions of Destiny, which should be interesting if we ever get copies of those. I hope we do. I hope we get copies. That would be nice, but probably not. There'll probably be a protective order that will preclude us from seeing those, which is very sad for us both. What are the odds given each count so far? I mean, I think that it seems prima facie valid. I mean, she's favored to win at the moment. It's a little hard to say. She didn't really dump enough receipts for me to have a strong opinion. Sometimes in complaints, attorneys will dump more on there to give you more of a sense of what's going on and you're able to assess more. This isn't one of those cases. This is fairly bare bones. So it's a little bit hard to assess. Is prima facie valid? The defenses don't really seem to work. Defenses are, I was hacked. Good luck. There seems to be text messages that contradict that. So, and message and other communication that relate to that. So I was hacked. It wasn't me. The Shaggy, it wasn't me, is a defense, but it doesn't seem to really work given what we see so far. Consent, she allowed me to. She told me it was okay. Well, that doesn't seem to really work given the messages that we've seen either. What else is left as a defense? Well, it was for the public good. It was for the public interest. I did it because the people have a right to know. It was in the name of the good of the order. Okay. So yeah, I mean, right now I'd favor her to win, 75%, I guess. So far. After this, there'll be a lot of other suits. That sometimes happens. Because he victimized other people, I know they have receipts probably waiting for discovery depositions. Could be. Yeah, could be. They should probably, if those other people are going to sue, they probably should sue now, to be honest. Because then their lawyers can coordinate with sharing discovery and stuff. They can share things they learn, and it will make the process easier for them all collectively. They can basically enter into a mutual compact to share information and discovery and so forth, and it'll make their lives collectively easier. Can Destiny get jail time? Not from this. It's a civil complaint. Whether or not Florida and or the U.S. attorney wants to bring a complaint in their capacity as the government is a whole nother set of issues. So That's up to the government, whether or not they're going to do that. There are a lot of instances of revenge dissemination goes to the defense of hacking. I mean, Destiny would be a likely person to be hacked. I mean, he's very popular, well known. He's also very controversial. So if people were, if you were trying to pick potential targets of a potential hack, Destiny seems like he might be higher profile on that than other people. There are people who might want to hack him for all kinds of reasons: monetary, revenge, spite. But there's the messages don't seem to really align with that, and his behavior doesn't seem to align with it. It's hard to imagine a rational person, like if it were me, right, and somehow images got shared like that were hacked. I don't think I'd be directing people about where to go find the images on X. Like, I was hacked. I was violated. This tape got out of my control. By the way, here's exactly where you can find it. That doesn't seem like the kind of thing I would do. So that sounds like that doesn't make sense to me. Destiny is libel proof? No. First of all, no. And second of all, he's not being sued for defamation. So I'm not sure why you asked. What else can I tell you? Some he even recorded in secret without consent in the first place. He might have been able to record the videos without consent. That's a whole nother set of issues. My best understanding under the operative law here is that I believe Florida is a one-party consent state. And so I won't swear to it, but my assumption would be that he's able to record this in secret. So the fact that he took the videos in secret is not the issue. Or it doesn't appear to be the issue. It's definitely not the issue here that he took the videos in secret. That's not the issue, at least for the moment. The issue is that he disseminated them, and that's a whole nother set of problems. His ability to record them and his ability to disseminate them are not the same thing. Florida's two-party? Really? Wow. Florida's a two-party consent state? Wow. I would have never thought. I'm surprised. I'm honestly surprised Florida's a two-party consent state. Wow. That doesn't seem like a very Florida thing. That surprises me. Okay, well then, strike everything I said and reverse it, I guess. Lol. Okay, never mind then. So he does need consent of everyone who has filmed a video. Never mind. My bad. Is it two-party consent or two-party notification? Strictly notification. Strictly notification. Consent is implied by the continuing to engage. Strictly speaking, it's not consent, it's notification. Yeah. How quickly do I expect this to move? Oh, that depends on the docket in Florida, to be quite honest. But I wouldn't expect it to move with any particular deliberate speed. It's going to take a while. It could take a while to get things docketed. It could take 6 months, before we're, looking at anything that really progresses. I mean, we'll definitely see. I mean, in terms of a decision from a court, yeah, probably 6 months at the minimum before we get anything from a court. I'm just trying to anticipate when various things are going to be filed and where various responses are going to fall. Yeah, 6 months minimum sounds about right. It's going to take a hot minute. For this to be resolved completely could take 2 years. More, depending on more if discovery goes wrong or gets hampered up in some way. Although this isn't the most complex case of all time, so I wouldn't expect discovery to get completely locked down forever. But, it could take a while. Would a settlement from the plaintiff include attorney's fees? A settlement includes anything you want it to include. It's a settlement. A settlement is anything you want it to include. It's an agreement. So, depends. Has this law been to the Supreme Court on free speech? I don't believe any revenge porn law has ever been to the Supreme Court on freedom of speech. No. And one of these is going to wind up at the Supreme Court someday. I'm pretty sure. I'm not sure when it's going to happen, but someday one of these is going to wind up at the Supreme Court. I don't know if it's going to be Florida's. I don't know if it's going to be a different one, but one day it's going to wind up at the Supreme Court. One of them. And if I were a betting man, at least one of them is going to be invalid. I don't know which one yet, but I do know the standards are very high, and it's you know, states are trying to cover conduct. So once some state somewhere has gone too far. Some state somewhere has gone too far. And we're going to find out eventually, but we haven't found out yet. Department of Transportation memo telling New York about congestion tolls. Haven't read it. I don't know anything about it. I appreciate the 338 of you who are here. I imagine this would be a more popular stream given Destiny. I'm surprised that more people didn't pop in given the topic with Destiny. I would have thought that would get a lot of people interested. Usually these YouTube things get a lot of people interested, but not so many people interested right now. It's interesting to me. Economouse says the court used a gold fringe flag and therefore has no jurisdiction. Destiny, probably, maybe. He's live? Lol. Yeah. Is he talking about this? Because that would be a very bad idea. But he probably is. Is Destiny talking about this? He probably is. He can't. He will not be able to keep his mouth shut. There's just no way. He won't be able to do it. He's going to say things. He's talking about it a lot. Great. Yeah. Well, those will be used in a future proceeding if it ever winds up at trial. You can remain reasonably confident. All right. Well, I guess I'm going to go ahead and end the stream for now. You sent me an email? That's nice. Thank you. Let's see. Who's streaming and who can I send you to? I'm not sending you to Destiny. Is anyone else streaming? Natalie the Lure Chick is streaming. I'll send you Natalie the Lure Chick's way. We're planning on doing a stream together on Saturday, I think. It's a clip of him saying he's the biggest victim. Lol. So I'm going to send you over to Natalie the Lure Chick. You know the drill. Be nice. We're going to probably stream together on Saturday around 1 p.m. And that'll be fun. Until later, my friends, I hope all is well. Cheers for now, my friends, and goodbye.